A very good evening and welcome to this edition of the 933 KFM Hot Seat. Charles Mwangu Shampagi, my colleagues Angelo and Bernard not in the studio tonight, or at least not yet here. And in the Hot Seat tonight, stolen money ends in the hands of private individuals. Is the IGG's failure to implement the Leadership Code Act also impacting on the fight against corruption? With us in the studio, Inspector General of Police, Inspector General of Government, Raphael Obudra Bakku. You're most welcome to the KFM Hot Seat.
Thank you.
Mr. IGG, you have a law that is supposed to help you track ill-gotten wealth, the Leadership Code Act. How exactly are you implementing the Leadership Code Act, apart from asking for declarations of assets and liabilities?
Yeah, thank you, and good evening, listeners. The Leadership Code Act was meant to serve the purpose of holding leaders accountable, both in terms of their conduct and also in terms of assets they hold. The Leadership Code Act requires that leaders should make a regular declaration of their assets, income, and liabilities. Actually, it requires that leaders should make these declarations every 2 years upon becoming a leader. The objective is to give opportunity for the Inspectorate of Government to assess whether the assets of the leader are commensurate with the income of the leader. And once the assets are found to be commensurate, then there is no problem. If the assets are not commensurate, to the extent that the level of assets a leader possesses is way beyond the income of that leader, the leader is supposed to be held accountable for the excess. Actually, the Leadership Code Act gives the Inspectorate of Government power to confiscate what is described as the excess wealth or asset the leader would have.
How much have you confiscated so far?
Now,
or how many people have you prosecuted based on that? I know you have prosecuted one.
Now, of course, the Leadership Code was not intended to create criminal offenses which would lead to prosecution. The Leadership Code Act was intended to be an instrument for administrative control of leaders. That is why the highest punishment that a leader could suffer is confiscation of what is described as excess property once it is ascertained, or property that is not declared or concealed but somehow discovered. Then it also requires that leaders who violate the Leadership Code should be disciplined through measures including removal from office or dismissal, demotion, warning, and punishments of that nature. But now, fortunately, for those who have been wishing that leaders who misconduct themselves be prosecuted, some of the breaches of the Leadership Code, which used not to be criminal offenses, have now been made offenses under the Anti-Corruption Act.
Is that a law that you're actually enforcing or using to fight corruption?
Exactly. Now, our main instrument for fighting corruption is the Anti-Corruption Act
of 2009.
Of 2009, which permits the Inspectorate of Government and the DPP to investigate the offenses and prosecute for the offenses which are listed under the Anti-Corruption Act.
Why aren't you using the Leadership Code Act as you should be using it?
The Leadership Code Act has suffered, I think, two problems. The first one was when we applied the Leadership Code against Honorable Luchamuzi during the previous term. After Luchamuzi's removal from Parliament, when he went to the Constitutional Court, as you may remember, the Constitutional Court ruled that the Inspectorate of Government was the appropriate tribunal or a body to enforce the Leadership Code, and therefore dismissed the petition of Luchamuzi. But when he appealed to the Supreme Court, the Supreme Court reversed the decision of the Constitutional Court, and it declared that the Inspectorate of Government was not a tribunal, and therefore it could not be the tribunal which was envisaged under the Constitution to deal with the members of Parliament who breached the leadership code.
But
that was a very big setback for the Inspectorate of Government, and as a result of that, now we cannot enforce the leadership code.
Charles,
According to
that the law is now obsolete.
According to the provisions of the leadership code itself, because the leadership code itself declares that the Inspectorate of Government is responsible for enforcement.
Are you suggesting, therefore, that the law is obsolete and unnecessary?
Yeah. So now, as a result of that,
first of all, the Supreme Court interpretation was the correct interpretation.
Okay, if it is the correct,
and
of course, whether it is wrong or correct,
what happened is just like the Inspectorate does not, first of all, make the declarations public, neither does it investigate and declare what the results of those investigations are. The Inspectorate has never pursued the tribunal that is stated in that constitution. When was a tribunal set up under that law?
But it is not the responsibility of the Inspectorate of Government to legislate. Legislation is vested in Parliament.
But there was a vacuum
The
there.
provision under the Constitution says that the Leadership Code Tribunal should be established by legislation by Parliament.
But it was
so
the responsibility
of establishing the tribunal through legislation is vested in the Parliament, and we expect that it should be, of course, the ministry responsible for ethics and integrity to spearhead that enactment. And we have been talking about it.
These are your colleagues.
We have been discussing it, and the steps are being taken to
After how many years,
verify
Mr. IGG?
No, but that one you cannot hold me responsible for. Lack of legislation is not the responsibility of the Inspectorate of Government.
What we're trying to argue here is that you have a series of pieces of legislation that you're not enforcing. Corruption is growing, and you're finding excuses for the growth of corruption. You failure to fight it.
We are not finding excuses. Under Article 234, and this is where we thought the Supreme Court made a mistake. But even if it made a mistake, it cannot be overruled by anybody. But it is very clear under Article 234, it says the Leadership Code of Conduct shall be enforced by the Inspectorate of Government or such other authority as Parliament may by law prescribe. So here, our interpretation had been we would be responsible for enforcement until another body is established that will take over. But
which body would that be?
Constitutional Court, the Supreme Court says, by virtue of the tribunal having been established, that means the Inspectorate of Government can no longer.
But you were not enforcing the Leadership Code Act. You just receive declarations of office and sit on them and do nothing about it.
I gave you the example of how we enforced it against Honorable Luchamzi.
But
that is what led to the decision of the Supreme Court. And once that decision came up, then we could no longer follow that path.
You ended up in trouble with that law simply because you applied it selectively on one individual against so many declarations.
You can't enforce the laws against everybody at the same time.
The Leadership Code Act is wide, and it doesn't just talk about the offense for which Luchamzi was sanctioned. But the issue of the tribunal has been ever present in the tenure of 3 IGGs.
No, that's
and also consistently we have said that the question of wealth declarations, that being public and a verification of that wealth has never been something that a single IGG has pursued. So this notion that somehow the problem is with the law and not with the leadership at the Inspectorate is preposterous.
Well, I can tell you that we have attempted within the limitations of the Inspectorate of Government to verify declarations of leaders. And of course, you can also suspect that many leaders will not declare everything. So now the really difficult we
they hide it behind spouses and other people.
The problem we would have is how to uncover or how to discover the wealth which is concealed. Because the leaders are not, they're also not stupid people, they're also wise people. What they declare is what they can justify.
Mr. Gigi, is it true when someone says that you have failed to use the easiest and most efficient available resource that you have, the Ugandan public, who knows who owns what? Because you keep those declarations secret,
and
the public
against
cannot
the law. Let me just point out that the decision by the IGG to conceal, actually to keep in the away from the public eye the declarations of leaders is illegal and against the Leadership Code Act and its spirit?
The Leadership Code Act provided that the declaration should be made public, but accessible through application through the prescribed form. And unfortunately, the prescribed form has not been prescribed.
Just like the tribunal.
Of course, the previous IGG, the Honorable Justice Tumwechije, one time certainly did. He released the declarations. But after that declaration, there was an uproar. The uproar was based on two things. One, actually the Attorney General of the time gave official opinion to government that it was illegal for the IGG to release the declarations.
The Attorney General's interpretation has no binding because that statute and the Constitution protects you and says...
Because the prescribed form through which the application was supposed to be made was not prescribed, therefore there was no mechanism for enforcement. I'm just telling you what has happened.
You can disregard. You can disregard the opinion of the Attorney General because I put it to you that the law insulates you from his interpretation. He serves the government. You serve the public.
That is one. Secondly, of course, the other problem, which I've also realized I'm still trying to really deliberate on how to resolve it, is the question of privacy. One of the conditions for even for release of information that can place the limitation is the right to privacy. How far can we go to release information which are of personal nature and sometimes also of people who are not directly leaders themselves? Because the Leadership Code Declaration has got information pertaining to spouses, has got information pertaining to children of leaders. So is it fair to discuss?
But you are an advocate on behalf of the public.
So what I'm saying is we have been addressing these issues, and those are the problems we have been facing. There is on the one hand the value of making the information available, and then on the other hand there is the value of whether it is proper to release information of personal nature of even people who are not leaders themselves.
Does your office function independent of the executive?
Certainly we do.
How would you be bound by the interpretation of the Attorney General?
We are not bound, but once interpretation has been raised, certainly you are obliged.
But Honorable Bakku should be making the argument on behalf of the public, not on behalf of the leaders. You see, you can't be a government watchdog and you give reasons as to why people should continue doing what they're doing. The superior argument here is that in Uganda, and the reason why the IGG, that office was established, is that institutional corruption is largely vested in a state-based political class. And we are saying the easiest way to catch them is let them declare their wealth and do so publicly. Now, that, by the way, which is written in the law, assumes that the cost of public service is that you are able to open yourself. That's why it's called public. The idea that now an invasion of privacy, which is being argued by Honorable Bakku as a reason, should be brought by the sitting IGG, to act as an excuse is problematic in itself.
Well, I'm saying that this matter has not been addressed for the first time. It has been addressed several times, but those are the issues which arise, which we are still trying to resolve. Once we resolve it in favor of making the declaration open, we shall make it open.
But Angelo has challenged you to say you should be acting more from the public side, not from the government side. Your defenses are acting from the government side, in defense of the government.
I don't know which one is government and which one is public, because the government represents
holders of public office.
Holders of public offices hold the office on behalf of the public, and the government is on behalf of the public. We should be putting them on the spotlight. So, but anyway, for the time being, what we have resolved is that if there is any person interested in the declaration of a particular leader, we would make it available to that person. But not for purposes of publication, but for purposes of access.
You're subjecting them to signing a declaration, and that declaration has conditions on it.
Not really. I don't think so. We have not imposed any conditions.
Let's take a commercial break and come back to this discussion.
KFM Hot Seat. The hottest debate on all relevant topics, live every evening.